Well, welcome back, everyone. I hope you've managed to stretch your legs and get a quick cup of coffee. Again, I've managed to get mine, so I'm all set. Um, we are going to look at now at the question of sharing information between government and non-government agencies and organizations, which is, of course, a very important aspect of tackling hate. And to start that conversation, I'd like to introduce my colleague, Dan Goodhart, who is the co-convener of the Tackling Hate Practitioners Working Group and a researcher at Deakin University, to introduce our next discussion. So Dan, over to you.
Thanks very much, Farhan. Good morning, everyone, and welcome to this morning's session entitled Parallel Approaches, How Government and Non-Government Can Share Information. So for those of you that joined us in our, right from the start of today, Michelle mentioned in her introduction the Practitioners Working Group on Tackling Hate, and where we seek to understand hate and our responses to it. So this Practitioners Working Group brings together community groups, academics, government agencies, including Victoria Police, to discuss our approaches to tackling hate and to build capacity. So this morning, we've already heard from Paul in terms of the model that's being employed in the UK, where police are including communities and academics, both in terms of sharing data and in terms of their approaches to tackling hate on the ground. At the Practitioners Working Group, one of the major issues that we've identified was that need to share data between government and non-government organisations. And in exploring this problem, it actually led us to the Office of the Victorian Information Commissioner, and specifically to Rachel Dixon, the Privacy and Data Protection Deputy Commissioner. Rachel was appointed to the position of Privacy and Data Protection Deputy Commissioner in 2017. Rachel has previously been the head of identity at the Commonwealth Digital Transformation Office and brings a wealth of experience in IT, telecommunications, big data, blockchain, and biometrics. So it's my pleasure to welcome Rachel to the discussion.
Good morning.
Good morning, Rachel. If we could please have both myself and Rachel highlighted, if that's possible.
I'll try and get out of the light a little bit because it's a bit glary there.
Great. Okay, so hopefully you can all see both myself and Rachel on the screen. So Rachel, I thought it would be a good place to start this morning just by outlining the role of the Office of Information Commissioner, just so that we can get an understanding of your remit and what you look after.
Sure. Well, I have one part of the responsibilities at OVIC. OVIC was formed through the merging of the previous Privacy Office and the Freedom of Information Office. So there are three statutory officers at OVIC. There's Sven Blumel, the Information Commissioner, who can deal with both the Privacy and Data Protection Act, but can also deal with the Freedom of Information Act 1982. There's a Deputy Commissioner who does FOI, but not privacy. And then there's me, and I just do privacy and information security. So that's the act is the Privacy and Data Protection Act 2014. Which has a number of parts that are probably relevant to the things that you're talking about here. And primarily that would be part 3, which deal with privacy, although there's also part 4 and 5, which deal with information security. And in particular, part 5 is all about law enforcement information security, which obviously is a factor in your discussions as well.
Okay, so maybe if we deal with privacy and information security separately, where we're talking, let's say in terms of privacy first, where we're talking about the broad areas that practitioners need to be considering when they're collecting data for research purposes, what are some of the privacy considerations that apply there?
Okay, so the Act is underpinned like there's a Commonwealth Information Commissioner as well, the Office of the Australian Information Commissioner, similar sort of Act, and both Acts have the principles-based legislation. So There are 10 IPPs, Information Privacy Principles in Victoria, and the ones that will be most relevant to you, all of them are relevant because of the life cycle of information, but the two that will probably mostly concern you will be IPP1 and IPP2. IPP1 is around the collection of information. In other words, what you have to do at the time of collection. IPP2 is around the use or disclosure of that information, which is the next bit. Now, they're actually separate IPPs because there are different things you need to look at the same time. Yeah, so when you're collecting information, going to your question, there are a number of things. The first thing is that you have to advise people why you're collecting the information. So if you're getting it directly from individuals, and in fact, you should always be trying to get it directly from individuals, except where that's not practicable. So IPP 1.4 deals with that. So you give a notice, a collection notice to individuals and say, this is what we want to get your information for. There's some purposes for that. And that becomes relevant in IPP2 because you can then only use the information for those purposes. So if you're collecting information and you say, oh, look, this is for the purposes of letting you park your car at the council car park, but then you go and use that information subsequently for something completely unrelated, then you've breached IPP2. So you've got to be fairly, it has to be informed consent. So people have to know what they're consenting to. And they have to have the ability to effectively refuse consent, or it's not meaningful consent. And that's an interesting issue. Now, in your context, obviously, there's information you'll be collecting not from individuals, but from other organizations like Victoria Police or like some community groups, things like that. And in those cases, those organizations need to be satisfied where they're operating under state contract that they are using that information in accordance with the way they collected it. So there's a legitimate purpose for that. IPP 2.1F has a provision which allows the use of information for law enforcement purposes where there's a particular harm to an individual's life or safety. So there are some exceptions here, but that's usually meant to refer to direct harm, like not sort of systemic overall sort of thing, but a harm to that individual. Where this is interesting, I think, is, and obviously I was really interested to see Paul's presentation this morning. There are lots of kinds of data that you can collect and use without it necessarily identifying individuals. But identification is something that's contextual. And there's a famous case, I think, the one that's easiest to refer to, for example, is that where people were using data thinking it had been de-identified. If people use de-identified a lot, and it's like, oh, we take the names and addresses and things out of this data, it won't be about an individual. But one of the things in the Act is that if it can be reasonably re-identified or identified by collecting other information as well, then it is still personal information, and disclosing it can be a breach of the Privacy Act. And I can expand on that in more detail further down the track. But just to come back to your earlier thing, I should just also clarify that my Act only comes into play where it is a state government entity or an organisation operating under state contract that is using the material. So VicPol, for example, as I say, I have a whole part of my Act that's just devoted to law enforcement. But the Department of Health and the Families and Fairness now, they're obviously bound by our Act. Department of Justice and Community Services is bound by our Act. And if you were, say, Microsoft, and you had a contract with the state government to provide some services, then for the purposes of that, the scope of that contract, Microsoft would need to be bound by the department. And I exercise my power through the department. So I would go to the secretary of the department and say, you must get Microsoft to assist me in any inquiries I'm making. And I don't just operate on the basis of complaints received. So any individual can make a complaint to my office in relation to a breach of privacy. But I don't just initiate investigations on that basis. I can also initiate an investigation on my own. And to get back to the identification issue, one of the ones that's particularly relevant, I guess, is the investigation we ran into Mikey Data a couple of years ago, which was, I think, the second investigation that I had launched. And that was the case where the Department of Transport had released a large data set, working with the Department of Premier and Cabinet, reached a large data set of all the transport touch on, touch off data from Mikey cards, taken all of the, taken all the names and identifiers and things out off those cards. Because one of the things that that data set included was timestamps, plus or minus a certain number of minutes, and location data, which is where it was touched on and where it was touched off. And of course, it's trivially easy in that circumstance to take some ancillary data and combine it. And in this case, for example, dozens, hundreds, millions of people have photographs on their smartphones, which get timestamped whenever they take a photograph. And one of the things that alarmed me, for example, was that I could find myself in that data set because I had taken a photograph of myself and my niece on a train going to the Royal Melbourne Show some years ago. And if I could find that, then pretty much anybody could find that. Because while I have some data skills, I'm not a data scientist. So that's the risk you run. That's, I think, a useful kind of beginning point. You can't just publish data sets. There are good ways to do this work. And one of the things that we encourage people to do is to manage the context in which you're dealing with data. Don't just put it up on the web for everybody to see, because then you have no control over the context and how that data will then be combined with other data. What you can do, however, is run it in a lab and put together a governance body that then says, well, hey, we're going to be looking at all this sort of data to try and determine patterns, to try and determine, for research purposes, and we're going to accredit certain people to access this lab, and we will be defining what they can and cannot use as ancillary data sources. And in that way, you can minimize your identification risk. And I think that level of maturity is something that we encourage. The Victorian government, on the same day that I commenced my commission, actually, established the Victorian Centre for Data Insights, which is a government entity. And the Chief Data Officer in the Victorian government has the ability to compel data and to, his job is to promote that kind of responsible data sharing, responsible data use. And we've seen that in several government agencies now that, for example, for quite a while, the Department of Health had a pretty good data lab where they were accrediting researchers, doing some ethical checks and all of that sort of stuff, but accrediting researchers to access material on some virtual machines in their environment so that they could never export the data, but they could certainly deal with the data on those VMs. Sorry, long-winded explanation. Long-winded explanation, but it's I don't want people to think that privacy is a barrier to doing the kind of work that you're doing. It's not. It's just there's a certain level of responsibility that goes with it.
And I think understanding that responsibility in terms of as academics and as practitioners, what we need to do and how we need to treat that data is extremely important. And that's really, I think, really the core of this discussion today. And definitely the lab I want to come back to, but I'll just put that to the side for one moment. Just to clarify a couple of things in terms of what you said there, Rachel. When you were able to identify yourself within the Mikey data set, you were able to identify your Mikey ID? Is that what you could identify?
No, they had obfuscated that. They had done it imperfectly. So the actual algorithm they'd used to do it did not actually generate a sufficient amount of randomness. There were some specific reasons for that. There were a lot of different classes of Mikey cards. For example, state politicians have a card that identifies them as a state politician. Police officers have cards that are for police officers. And as a result of some of those kinds of factors, there were pieces missing from the data set. And so when they did the anonymization, the de-identification, it wasn't as random as it should have been. That wasn't actually how I did it. It was quite basically to just go to my phone, my iPhone, which had a snap on it taken at a station very close to the showgrounds, where my niece and her best friend were on the train, and I had taken a photograph of the two of them because they were wearing silly hats. And I could basically say, well, at this time, at this place, I was there then. I am one of a group of people in that data set at that time. So go drill down through the data, find the location of the tap on or tap off. And in this case, the tap off was showgrounds. I know that I tapped off no more than a minute and a half after that. I know that there were 2 other people with me topping off at the same time. I know that we separately had caught a tram, the 3 of us, the day before. And so then all I have to do is look for those 3 individuals, or to match 3 individuals from that particular time and location with 3 individuals from the Collins Street tram stop who had touched on a previous day. And again, I had photographs to track both of those. A more famous example, because this is just one, obviously, that I didn't publish, but researchers at Melbourne Uni. So you may have come across a woman called Vanessa Teague, who was previously at Melbourne University and is now runs her own cybersecurity company. But she and some colleagues had done some work on the Medicare data set that was released by the federal government some years earlier than that. And they'd identified Kevin Rudd in that data set. And they've been able to do that because there was a newspaper article some years earlier about Kevin Rudd having heart surgery in a Brisbane hospital. And the newspaper article referred to which hospital it was. And of course, there was a date on the article, so they knew when it was. And Kevin Rudd is a particular age at that time. So they were able to go into the data set, say, the procedure was quite specialized. And so they're able to say, well, which procedure, here's the billing code for that procedure, was done in Brisbane that day. And there were very few of those operations done, and only one on a man of that age in that hospital on that day. So it was quite trivially easy, just given the newspaper article as the corroborating data source, to re-identify an individual in that data set. Helps that it was famous. Trying to find an anonymous person, a person that you don't know about, is harder. But from the purposes of the Privacy Act, if you can find a person, then the data is not really de-identified. Excuse me.
I think when we last spoke, that point about re-identifying people from a seemingly de-identified data set was a really interesting point that I needed to go away and think about. And so I'm sure there might be some people on the call today who need to kind of consider this, because it's the point that you've made there in terms of, if you can identify one person, then it's not truly de-identified, and it may be impossible to truly de-identify the data set. I think is something that's really important for us to think about. Just going back to a point that you made there about who this applies to. So if we think about in our practitioners working group, we've got government, which you've already mentioned, but then we've also got academics and other not-for-profit community groups. Does this apply to those groups in some way if they're not using government data?
If they're not using government data, then they'd probably be bound by the Federal Act, which is the Australian Privacy Act, which is handled by my colleague Angeline Falk, who is the Federal Privacy Commissioner. Now, there are some carve-outs in Australia. One of the reasons Australia does not have GDPR equivalents, for example, with Europe, and so we can't share information with Europe in the same way, is that organisations with a turnover of less than $3 million are not subject to the Federal Privacy Act. However, if you are a small community group and you are receiving funding from the state government to do your work, then you have a contract with the state government. And at that point, my act is enlivened, and you would fall under the Victorian Privacy Act. So it really depends on whether there's a contract. And as I say, when there is a contract, I don't just come knocking on your door and say, hey, you're doing the wrong thing. I would ask the department that is administering that contract to then bind you to our act. And most state contracts include provisions that require people to respect the law. So that's a fairly easy thing. Can I just say one more thing about the de-identification, just to be clear though? There are other ways to do this, and it just depends on what you're looking for. Obviously, you can use a principle called k-anonymity and say, well, we're going to fudge up this data such that we're going to just make it about clusters of people. No individual, but we're just going to report on a cluster, and our K and number might be, groups of 10 people. So that you'll say, well, this happened to somebody in this group, but we can't be more precise than that. That's useful for some research purposes, but not others. And where you're looking at specific instances, like, for example, instances of hate crime, probably not terribly useful. because there'll be fairly specific instances on specific days at specific places. So anonymity is probably not going to help you a great deal unless all you're looking for is systemic trends and say overall how many, in this year, how many events did we have? Well, that's fine. That's something you can aggregate all of that data, and that reduces that re-identification risk. So it's not impossible, but in those situations, you really want to consult a data scientist.
Great. I just encourage everyone listening to please put your questions into the questions section at the bottom. We are going in this session for another 25 minutes. I will move to questions shortly if we do have questions from the floor. Let's now move, Rachel, in terms of the information security and what you started explaining about the Well-Governed Data Lab. So if this was, let's say there was government data being used, but a university wanted to set up such a lab, what would be some of the characteristics of that lab to ensure that it sort of met the information security provisions?
So the Part 4 of my Act actually deals with a risk-based scheme. By the way, some universities are actually bound by my Act as well, but not Part 4, they're bound by Part 3. Yeah, so it's a risk-based thing. Obviously proportional. We don't expect people to spend gazillions of dollars protecting information that's not particularly sensitive. That's a very poor use of taxpayers' money. But where there are risks of exposure of personal data, then that's an important thing. Primarily, I think in terms of working with data, the big issue is knowing the people who'll be working with that data. Having some sort of accreditation program such that a person applies to work with that data and then has to talk about the purposes for which they want to use the data. Because going back to the IPP discussion earlier, if their purposes are not related to the purposes for which that data was collected, then you may not be able to give them access to it. And that's a fairly important consideration. But also you want to look at the ethics of what they're doing. And I think, some of the cases that Paul talked about earlier this morning about, organizations that might want to get on board and assist, you've really got to make sure that their purposes are as ethical as your purposes. So the accreditation piece, the review, and as I said before, the issue there is what you really want to do is not just set up a big data lake or a big pool of data, but actually give people the ability to work with that data in that environment. So, something like a cloud environment or something like that, where you've got good multi-factor authentication, and you can say, well, I know that this person who's accessing this is, Dan, and Dan is logged in, and Dan is not exporting that data. Dan is just running his models in R or Python or whatever it is that you want to run on that data in that environment. And you can generate reports and you can generate summaries and all of those sorts of things, but the raw data never leaves the environment. So you minimize that first of all, re-identification risk, but you also reduce the risks that the data will just be siphoned off onto somebody's desktop machine because it might come in handy later. And I used to work, I worked for a while in a very large banking and insurance company with a lot of data scientists who were doing pricing and things like that. And, enthusiastic people working with data always love a good data set that they can practice on or get interesting insights from. And I appreciate that, but you've got to minimize the possibility of that exfiltration of data. So, rate limit an API, prohibit certain sorts of connections, that sort of thing.
So when Paul was talking earlier about maybe some of the social media scraping and that sort of data collection, do you see these sensitivities being similar, or would that be a completely different category because it's sort of not, it's data that people have volunteered because they've put it onto a sort of open platform?
Yeah, they have. Look, social media is very complicated because the issue of who owns the data is sometimes an interesting piece. Generally speaking, I think, cases that have involved social media generally hold that when the data is published on a social media platform, it is published. And so at that point, it is something that is sort of out there. I wouldn't ordinarily say that is particularly particularly sensitive data, because yes, it was clearly put out there for a reason. There are some caveats on that. You will find occasionally, for example, that you'll find people who have quite tightly locked down social media profiles, for example, Facebook pages or something, where people will take people might take a screenshot of that material because it's not available to the rest of the world, and then share it with the rest of the world. And that obviously is something that the person who posted it did not intend to be public. And so but the question there is, it's slightly cloudy because that depends on the terms and conditions of that social media platform as to who takes responsibility for that. The American ones, of course, are currently shielded by a certain section of the Communications Decency Act from liability in that situation. So you'd probably say it's the individual's responsibility. But in Australia, the laws are slightly different. But, you know, I don't think, it certainly doesn't concern me, because those big publishing platforms, those big social media platforms, are actually not in my jurisdiction. They would be
okay. And if we considered the same question with, let's say, court documents or maybe media reports, how would that work?
I do not have anything to do with media reports for obvious reasons. Can I just put a small caveat on this? So yes, if you've got a newspaper article, it's a thing that has been published, but there are circumstances in which that article might be retracted. There was a recent case in Victoria where a newspaper owned by one of the major newspapers ran a story about some children who had been subject of various orders and had been subject to abuse. And the Commissioner for Young People was successful in getting that material removed from the web and a permanent injunction put on republication of that material. If you had a copy of that thing from before the court order, you would obviously not be permitted to share that material. So you have to be careful of the information life cycle there. This is less an issue with digital material, because typically the digital material goes away. Print copies, of course, may still be in the State Library.
And one question that's come through here just asks, what if a group of organizations share identifiable data in outputs, but are shared in terms of the trend? So I think the question's asking, the identifiable data is shared in a situation where identifiable data is shared across different organizations, but then when it comes to the outputs, the deliverables, the reports, that is trends, aggregated data, etc. So I guess it would be in a situation where you maybe have this data lab, but you have adjoining data labs or adjoining data sets. Would that complicate things? Would that make it more difficult?
So it gets a little hard to explain, because, as I say, it's all about the context. Your risk is all about the context. There is no one size fits all in this situation, because your identification risk depends on the data. It depends on the circumstances in which the data was collected and what data sets are being recombined. And that's why that governance piece that I talked about earlier is so important, because before doing that, you'd have to have somebody look at those things and say, well, what is the risk here? Can I do an analysis? And basically it's math. You know, what is the likelihood that this plus that will result in re-identification? And you have to continuously do that. You can't just sort of set up this framework and then say, I'm going to plug that in, I'm going to plug that in, I'm going to plug that in, because then you have no idea of context. And that's not responsible. So now, but to address your question more properly, of course, yes, that's why I recommend the idea that you don't take data out of the lab. You take the reports out, because the reports are easy to aggregate, to put together in forms that will not be reverse engineerable. One of the things that I'll just put a caveat on there, of course, that does not prohibit you from having peer review, because then you can accredit a peer to go back into the lab and reproduce those results, because you've still got the data, right? So the fact that you're obfuscating the raw material does not mean that you can't use your research in a way that can be verifiable, but you then accredit people to go in and do that, that proving without having to actually give them the entire data set from scratch. And I think that is a responsible way of dealing with these sorts of problems. And it doesn't prevent you from doing things that will result in the kind of publication of issues and trends and all of those sorts of things that are not re-identifiable down to the unit level. But yeah, unit level data is almost impossible to de-aggregate, to de-identify.
Yeah. So one question here is asking, when we're talking about the data layout, obviously you've got options between storing it on a server versus storing it in the cloud. What would your advice be in terms of protections around that? Because obviously there'd be some advantages to having it on your server where you can sort of control that environment a little bit more in terms of who has access. But then conversely, in the cloud, maybe there's more levels of security based on that data center. So how do you sort of compare those two things?
One of the things I try not to do is design systems for people. I used to do that. In my role, it's kind of inappropriate for me to suggest that this is a thing you should do because I might actually have to come and review you later. But look, provided you know what you're doing when you set up a cloud a service, and you've got a couple of, if it's Amazon, for example, you've got your S3 buckets where you may wish to store some material. You may have some of it in Glacier, whatever else you're using. Provided you know what you're doing when you set that up, and you've got your user roles all sorted and all of those sorts of things, which is sort of true for even if it's a physical server. If it's a physical server, you still need to have a very good idea of what your firewall settings are and which ports you're opening and what ports are being opened for what reason, et cetera, and making sure that you're not privileging various admin tasks to run automatically with root or anything like that. And all of these things require a certain base level of IT knowledge. I have to say that, there's nothing inherently wrong with cloud services. And in fact, in some ways, they can provide a lot of those things for you. There are some restrictions on trans-border data flows. So you want to be very careful about which zone you set your cloud service up in. You want it to be subject to Australian law for obvious reasons, and preferably, so the way the acts work generally in Australia is that if it's in a jurisdiction like another state, like it was New South Wales, for example, we would say, well, the Privacy Act in New South Wales is broadly comparable. There are broadly comparable protections in that jurisdiction. So therefore it would not be a breach of the trans-border data flows issue. But, frankly, there are points of presence for big data platforms in pretty much every major Australian city now, certainly plenty in Victoria. So that's not really going to be a problem for you. From a financial perspective, it may be that you've got accreditation with the university that can afford to give you some computing power. And in a situation like that, you just need to work with whoever was the responsible person at that university for that kind of infrastructure and ensure that they knew about their security settings that were required and about the accreditation of individuals to use that. Years ago, I used to be on a board of a supercomputer centre in New South Wales. It was the only for-profit supercomputer centre in the world, which is probably why it's not there anymore. Not quite true. It got resumed back into the New South Wales government. But that was a partnership between major universities and the state government to run meteorological modelling, all sorts of things. And before we would let a researcher onto that platform, we had to be assured that they had some minimal levels of skill and that we were confining them to essentially the bits that they needed. They didn't have a full run, obviously, of the platform for obvious reasons.
So I've got a question here which asks, how protected is data of online extremists and perpetrators of hate speech? So maybe this goes back, I think, to sort of where we started in terms of the rules around the collection of data. So obviously, if you're collecting data about perpetrators, about hate speech, etc., you're not going to be seeking the approval of that person in order to collect the data. So how does that part of the process work?
So it comes back to your purposes. Bear in mind that however much people might not want this to be true, racists have human rights too. I appreciate that's not a popular sentiment, but it does mean that they would be entitled to complain to my office or to the federal regulator for a breach of privacy if they became aware of one happening. So, you know, you've got to have some respect for the law. Just because people are doing incredibly distasteful things does not mean that you are free to do various things. Again, to come back to your earlier point, if these people have published material, yes, if it's not practical to collect the information directly from them, then you may have an exception to 1.4 because it needs to be reasonably practical. Obviously, if you're dealing with an outlaw motorcycle gang, and they're going to come and, you know, firebomb your house if they think that you're, you know, too interested in them, then it's probably not reasonably practical to go to them and say, hey, I'd really like to know about the, you know, about all of your activities. But bear in mind, where is this information coming from? And the information is probably coming from law enforcement in a situation like that. And so law enforcement has to be satisfied that the purposes for which you are using the data, that they are disclosing it to you, is part of the you know, is part of the purposes for which they collected it. I would say that you've possibly got a pretty good case to argue that the kind of research that you're doing is something that may minimize crime in the future, and so therefore it could be for a valid law enforcement purpose. You'd really have to talk to, if you're getting information from the police, that would be a matter for the police legal department to give an opinion on, because it would depend specifically on what the information was. If it's, as we say, open source, if it's material that's been published in newspapers and stuff like that, then to your earlier point, provided there's no rulings that have redacted any of that information, yeah, you should be free to use it. It's out there. Little caveat, just because information has been published does not mean that it's not personal information. It can still be personal information, even though it's been published in the public domain. There are some gaps, I think, and this has been tested in a couple of cases. There are some gaps in the interpretation of whether or not something is publicly available, whether it still becomes personal information. And this gets really interesting in the case of things like data breaches. So the fact that your information may have been published in a data breach, may have been leaked onto the web, does not mean it stops being your information. If your email address and phone number and address and date of birth and Medicare number has found its way onto the web somehow, the fact that it's out there doesn't mean that it's not your stuff. It is still your stuff, and you have a right for it to not be used further. So you just need a little bit of caution. And as I say, it goes to, where is your data coming from? Do you have a valid purpose for that? And, you know, can you control where that information is then going?
So I understand that sometimes some of these principles can be waived under very specific circumstances when it's in the public interest. And so just to sort of build on that previous question, if we flip the scenario around and there was a community group gathering incidents or examples of hate speech, which they wanted to gather and provide to the police, how does that work in terms of their collection and use of that data, where they're also, as we just described, not seeking the approval of the perpetrator, but
it's legally complicated is the answer. The problem would be, first of all, as a community group, I'm going to guess that they don't have $3 million worth of turnover, so they're probably not bound by the Federal Act.
Right.
If they're not under state contract, they're almost certainly not bound by my act. So they're in this sort of legal grey zone in which it would be difficult for the subject to make a privacy complaint because the organisation is too small. Whether that stays true, of course, there's a lot of people who would like to see that that $3 million threshold abolished to bring us into line with international best practice, because there's no such threshold in Europe, for example. Small businesses are just as bound by the Privacy Act as large businesses. And there is currently a review of the Federal Privacy Act being undertaken right at the moment. So that is obviously one of the things that is up for discussion. But let's say that a community group does do this, and then they disclose that information to somebody else. but the somebody else is bound by the Privacy Act. The somebody else may not have the authority to collect that information. That's where it gets tricky, right? Because the information is being collected by somebody who's exempt because they're too small, they're not part of government, but then they give that to a government department, right? What are the circumstances? What is the authority for the government department to collect that personal information? And again, that would probably fall foul. While you could probably make an argument that the department can't go to the individual to collect it directly. Secondary collection is one of the IPPs. It's part of IPP1, and you want to be careful about the department's authority, or the police, for example, authority to receive that information. Now, if the work that the community group has done does indicate that an individual is a threat to public health and safety, then there are exceptions in the Act for that. And likewise, there are, and not all state privacy commissions have this, by the way, but Victoria does. The Information Commissioner and I can write an instrument which varies the IPPs where there is a public interest, whereas it demonstrates. And so an application for either a temporary or a permanent public interest determination can be made to our office, and then by a government entity, somebody bound by our Act. Somebody not bound by our Act obviously can't make the approach, but can make an application to our office to say this information is necessary for, for the public good. Like the last one we wrote was around the bushfires. I think it's about a year and a half ago now, where the government wanted to contact the families of people who had died in the Black Friday bushfires for a 10-year commemorative service. The government had obviously collected that information in the first place to deal with the emergency as it was 10 years ago. The purpose they were using it for 10 years later was different. There was no emergency. It was to have a memorial service, not a related activity. And so they applied for a public interest disclosure, to a public interest determination to our office, and we issued that, and then they were able to invite people to the memorial service. So there are circumstances in which that can be done. You could envisage a circumstance where the Department of Justice, for example, may wish to apply for a public interest determination in order to work with that data to do certain things. And what happens then is they make an application to our office. There is a consultation period, usually about 30 days, where we put that up on our website and invite people to respond and object if they think it's unreasonable, and then we issue a determination. It's a power that we don't use a lot because there's a bit of paperwork involved, and that public interest test has got to be fairly robust. But it is a possibility in Victoria, at least.
Because what we're saying there is that the organisation which is under that threshold is sitting in this grey zone. They can probably collect it, but then the government agency that they may want to provide it to may actually need to seek that waiving of the principle in order to actually be able to collect that information back from them.
That is possible. Yeah. That is possible. Yeah.
Right.
Yeah.
Okay.
Where there is a threat to life and safety, then there's an exemption in the IPPs for that. So you can say, well, this is necessary to prevent, harm. But bear in mind, though, that has to be sort of a direct problem, not a this will make the world safer kind of issue. It has to be something where we think this person's going to get killed, or maimed, or beat up, or whatever, and that would be a valid purpose. But that would relate to a specific incident, not to a general trend, if that makes sense.
Yeah, but I guess in the context of what Paul was talking about, where hate speech precedes action, and you can always see the signs afterwards, but not necessarily beforehand. What that actionable intelligence, so to speak, is very difficult to sort of gauge.
So I won't talk about that. We have another public interest determination before my office at the moment, which we have not issued yet. And so I won't talk about the specifics of that. But it's an interesting case where a department absolutely has a valid purpose for collecting the information, and not the purpose for which it was collected. But it has to be kept separate from another department for legal reasons. And so they want to be able to do this in a way that they can contact individuals and work with data. And my office is very sympathetic to that. And I think that, the sorts of things that you're outlining here, if the Department of Justice or somebody like that was to come to us and say, well, we are interested in receiving these kinds of things from community groups, et cetera, we would have to do some looking at it. Every case is different. And we would have to be satisfied that the individuals who were providing the information to the department were responsible and not just, basically going around defaming random strangers. I'm not suggesting that's what's happening in this case, but we would want some protections of human rights. The fact that I can't regulate those community groups does not mean that I'm not bound to ensure that the department is dealing with that information appropriately. But yes, if a department wanted to come to us and say, we can see a scheme where we get this information and then we, the department, work with some researchers to aggregate X, Y, and Z, we would be sympathetic, I think, to looking at how to make that work, because I think you probably would not have too much trouble mounting a public interest argument, but it's a lot of work. I'll just preface it by saying it's quite a lot of work to do something like that. We are fortunate to have that power. As I say, not all privacy commissions in Australia have that power. Victoria does. There's one other caveat. I don't do health data. Anything that is a health record, not our responsibility. That belongs to the Health Complaints Commission in Victoria. It's one of those interesting sort of accidents of history. So to the extent that you're working with health data, a health record, for example, the consequences of an incident or something like that, where if it's an actual health record that you're working with, as opposed to just a newspaper story or something like that, then I am unable to write an instrument varying the use of health information. I cannot do that. Likewise, ambulance, I think there's ambulance, there's multiple hospitals and health services. If the data is coming from there, I cannot write anything in that regard.
Okay, we've reached 11:30, so thank you very much, Rachel, for this discussion. I think it does sound like it is going to be a lot of hard work, but I think it's definitely going to be something that is of interest to the practitioners working group to pursue. So I'm sure this will lead to further discussions. So thank you very much for your time today.
Thank you, Dan. Look, I just say to people, I know that you've sort of prefaced LinkedIn and that sort of stuff. I have a LinkedIn account, but I never look at it. So please don't try and send me messages to LinkedIn. They will just sit in the great box. But there is an inquiries line at OVIC. There's a privacy email address at OVIC. Write to my office. My staff will hand it on to me, and I'm happy to engage further if that's of help. I do think this is a very worthwhile initiative that you have going. So I wish you the very best of luck with it.
Thank you very much, Rachel. And now hand back to Jerome.
Thank you.
Thank you so much, Rachel and Dan. Fascinating conversation, and of course, very important for those researchers who are trying to obviously collect data, deal with data, and make sense of how we can contribute to social harmony in Australia and elsewhere. We are going to have a very quick break for about 13 minutes or so. We come back at 11:45 for a conversation with Ro Allen, the new Victoria's Equal Opportunity and Human Rights Commissioner. So enjoy your break. See you shortly. Thank you.